Hi. Welcome to the 8th episode of our talks about distribution agreements worldwide, dedicated to India. Our speaker today is Ramesh Vaidyanathan, our expert based Mumbai, interviewed by Roberto Luzzi Crivellini. The main topics discussed are the regulation of distribution agreements in India, important clauses in these agreements, main issues that tend to arise in distribution contracts, and how to manage conflicts in an effective manner. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hi Ramesh, thanks for joining us on another episode of our distribution talks. This time it's about India, so thanks for joining us. And my first question for you would be, as we tend to start our conversations about rules and regulations. So how are distribution agreements regulated in India?
Thank you, Roberto. I'm very happy to join this conversation on distribution agreements in India, and what are generally the broad legal principles that one must keep in mind when one is dealing with a distribution relationship that has a connection with India. So, if you look at it, India is a classic nation of shopkeepers. If you can look at it, we're about 1.4 billion people, the largest population of the world, and we have nearly 15 million retailers in the country. So you can imagine it's a huge distribution economy of gigantic proportions. And so if you look at the law dealing with distribution, we don't have a dedicated or specialized law dealing with distribution agreements. So most of the decisions involving distribution agreements are essentially written down in contracts, and the contract would be the governing document. There will obviously be some other laws that will apply depending on the nature of the distribution relationship. For example, the law dealing with sale of goods will probably be involved. Consumer protection, competition, depending on what sort of relationship, what sort of impact the distribution will have on the market. Needless to say, tax laws, again, something that will have some impact. IP, very, very important from any distribution standpoint, and particularly in the Indian context, when you need to be absolutely sure that your IP is safeguarded if you are the IP owner. The other thing perhaps peculiar to India is the Foreign Exchange Management Act, which is essentially a law that deals with control of foreign exchange going out of India and coming into India. So you will want to check whether the payments and other transactions planned under the distribution agreement, whether they are in compliance with the foreign exchange regulations of India. And then on top of all this, you could also have product specific laws that will apply depending on what product you're looking to distribute or whatever. So those are generally the broad overview of things that you will need to look at from a legal standpoint, if you're looking at an Indian distribution arrangement.
Okay, thank you. If we start to consider the contract itself, what are the main issues that, based on your experience, tend to come up frequently in a relationship between a foreign manufacturer and an Indian distributor?
Sure, yeah. So essentially, if you look at it, some of the clauses that would apply across the board for any country would obviously be relevant from an Indian standpoint as well. Things like exclusivity, clear definition of territory for the purpose of the distributor, whether it's going to be India. And in India, keep in mind that it's a huge country, and normally, companies have a tendency to break the territory into multiple parts for the purpose of managing the distribution, because it's very difficult sometimes to have one distributor, run the show for the entire country, given the size of the country. So that's one aspect. The other thing is, I would say, in terms of the payment terms, extremely critical. What sort of credit period you have in mind? What sort of guarantees do you have in mind? I think all of those things will be absolutely critical. I would say the other key thing, again, more general, would be the description of the product. What's covered, what's not covered. And I remember, a few years back, getting into a litigation in India where the key determination was whether the definition of product, which was already listed and capitalized and defined in the agreement, but elsewhere in the agreement, it was actually used in small case and not in capital case. So the question before the court was whether this was intentional or an oversight. So I think it's very important for us to be able to define product very clearly, upgradations, what's covered, what's not covered. So that's critical. The other thing I would probably say important is also the purchase order protocol. What kind of timeline do you have, or what sort of format do you have for the purchase order? What sort of lead time do you provide for it? Are you required to honor all purchase orders? Do you get to say no? So all of those things are also extremely critical, and you must. How do you accept a purchase order? What are the timelines? So all of those aspects would probably be critical as well. I spoke briefly about price. What are the payment terms? That will be important. I think delivery terms extremely important. When does the title pass? When you are dealing with, let's say, particularly when you're dealing with supply of goods from outside India to an Indian distributor, who picks up the transit risk? When does the title pass? Who is the importer for the purpose of Indian tax laws? So all of these questions become extremely important, and all of those will have to be clearly defined. Then you have all the other aspects which would be typical to any agreement. For example, product training, after sales service, performance targets, all of those things. So I think these are some of the things that I would particularly watch out for in distribution agreements. The other clause which is important is dispute resolution, which I think we will talk about it perhaps a bit more in detail later on in this conversation.
Yeah, we will. How about Ramesh, termination? Because on my experience, that's the moment when things need to frequently go wrong between the parties. So, in terms of, for instance, prior notice and duration of the contract, what's your view on the matter, especially if we're considering long-term agreements? So if there's case law or there's practice that is generally followed on that matter, that would be my first point. And then the second one, whether you see litigation tied to indemnities for the distributor, so claims for compensation for the goodwill generated in favor of the manufacturer.
Sure. Yeah. So essentially, as far as termination is concerned, the terms of the contract will continue to operate. So you will be governed strictly by the terms of the contract. And it's very important for the terms to clearly say what happens upon termination, whether it's a 30-day notice, 60-day notice, and there will be a clear provision for material breach. If there's a material breach, then what's the cure period for the material breach? And also looking at whether something is material enough or it's more a technical breach. So it's very important to define these terms very clearly. The other thing that's extremely important is things like insolvency, bankruptcy. Those should also be identified and listed as termination events. any fraud, illegality, all of that would also be, causes for you to terminate under the agreement. If you're terminating without cause or termination for convenience, I would say a reasonable notice period should be provided. It could vary from 60 days to 90 days to 120 days, depending on the industry, depending on what sort of inventory the distributor is holding and all that stuff. The other aspects to look at from the termination standpoint would be, for example, how do you settle accounts, payable to each party, and you have a timeline fixed for that. How do you deal with pending, orders which are in the process of being executed? And I think most importantly is the clear separation as far as the IP is concerned. You do not want a situation where the Indian party, let's say Indian distributor, is able to hold on to the IP. I must mention a very well discussed litigation in India a few years back when McDonald's was involved. McDonald's USA was involved in a dispute with its counterpart in India, and the Indian court actually let the Indian distributor continue to use the McDonald IP even after McDonald's had terminated the contractual relationship. So those are very important aspects one must look into before looking at separating and planning the separation in terms of the distributor and the owner, so to speak.
Okay, thanks. And it would be interesting maybe on another talk to know more about the McDonald's case, which seems to be quite interesting to me. Staying on that note, meaning litigation and how to prevent and manage and solve disputes, what is your recommendation? What do you normally advise clients to set forth as a dispute resolution clause in their distribution agreements with an Indian distributor?
Sure. I think it's an extremely important question and perhaps something which is very, very peculiar to India, that Indian courts are very slow in terms of disposal of cases. So it's not any reflection on the quality of the judicial system. It's just the volume of cases that the judges have to deal with on a day-to-day basis. So you must look at creating a structure that keeps you away from Indian courts for this reason. So you must find ways to create an arbitration clause. Perhaps all disputes should be resolved by arbitration. India has a very good arbitration system. You could get a verdict in 12 to 18 months, which is very good. Even when you get an award, let's say, you can choose to have your arbitration conducted outside India. If that gives you more comfort, those will be enforceable in India. You could have Indian governing law. You could even have an international law, like an English law, whatever, governing your contract, as well as arbitration. And but having said that, if you feel that you're not looking to, if the stakes are not too high and you're not looking to spend a lot of money in arbitration, maybe a court process may still make sense. If all that you're looking for, let's say, is only an injunctive relief, preventing someone from, let's say, disclosing confidential information or misusing certain IP or whatever. And the other aspect I must mention is Indian courts do not grant very large amounts of damages. They're very conservative when it comes to awarding damages. So sometimes you may want to be able to extricate yourself from the relationship more than really trying to get damages out of your counterparty, because that's going to be a very long process. And so therefore, I would say predominantly as a default option, you should look at arbitration and choose an institutional arbitration. And for Indian seated, I mean, Indian contracts, Singapore has been preferred as a preferred seat for arbitration because it's just easier, and it's got a common law system, and it's also neutral. So you may want to consider that. But if the stakes do not allow such a large, I mean, if such an international arbitration, you can still arbitrate in India. Then I would request that you choose one of the big commercial centers, Mumbai or Delhi, to seat your arbitration, because it's just going to be easier to be able to get things going in some of these bigger cities.
Okay, this is well noted. Thank you. What if in some contracts the parties provided for a foreign court to hear the matter, and then eventually you have a foreign court decision which needs to be recognized and enforced in India? How difficult is that, and is it a good idea anyway to get such a clause in your contract? Uh, does it lead and to litigation again in India with all the throwbacks you just pointed out, or
Well, you do have some risk. So the way it works, let's say if you have a judgment from a court outside India, the first thing to check is whether that court is recognized by India as a court of a reciprocating territory. So what that would mean is certain countries, and more importantly, certain superior courts in certain countries, have been notified by India as reciprocating territories. So if you have, if those courts pass those judgments, those will be treated as Indian court judgments. So then, when you bring it to India, you're actually filing for execution of the judgment,
okay?
and not starting the process all over again. But obviously, the Indian party will say, well, I was not heard. This is actually completely in violation of Indian law. So there are some defenses available to an Indian party. But the first thing to check with your lawyer when you're drafting a contract and you're providing for, let's say, the courts in New York, or let's say courts in Zurich or wherever, is to ask the Indian lawyer, if tomorrow I get an order from this court, will the Indian court enforce it against an Indian party? I think that's the first check one must do at the time of drafting the contract, because that's not something you want to deal with at the time of enforcement.
Exactly. Yeah. Well, thank you. This is very well noted, and we will link for those who want to know more and go deeper to the information which we have available on our website at Legalmondo on distribution agreements in India. I look forward to our next chat, maybe on the McDonald's case. And for the moment, thanks a lot, Ramesh, for this chat.
Thank you, Roberto, for the opportunity.